defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by Hollis, Wright, and Couch, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the Hollis, Wright, and Couch Law Firm and host David Lamb.
Hello and welcome into the attorneys. I appreciate you being with us on this Sunday evening. For the next half hour, the whole goal of the program is to provide a panel of experts to answer your tough legal questions. For that to take place, you got to get those questions to us. You can call, text, email, that information displayed on the screen throughout the program. Leading our conversation tonight from the firm of Hollis, Wright, and Couch, Mallory Schneider. Mallory, good to see you.
Good to see you as always. And today we have a fellow attorney from Hollis, Wright, and Couch, Josh Firth, who's here to talk to us about special education laws in Alabama. Specifically, what rights do special needs children have and their parents here in Alabama?
Yeah. Josh, good to see you.
Good to see you, David. Thanks for having me back.
Thanks for being here. And kind of from an overview, let's talk about, so often Josh Wright will say, the whole goal of the attorneys is to deal with issues that matter, that are relevant, and help explain some issues of the day. This certainly is one of them. Why? What's the impetus behind the program tonight?
Well, I guess I'll jump on that one. Special needs services in the country and in Alabama are on the rise. And one of the things that we find so often, and I'm speaking about this topic, it's not just professional for me, but it's personal. My oldest son is a special needs child. He's a high-functioning autistic child. And so my wife and I deal with this on a day-to-day basis. But when you've got 80,000 children in the state of Alabama who are receiving special needs services day to day in the schools, you have roughly 6 million children, according to the U.S. Department of Education, as of 2009, who are receiving special needs services in the school. It's a topic that's becoming more and more mainstream, particularly with the prevalence and the rise of, for example, autism diagnosis. People see those commercials that come on all the time, and maybe you hear it on the radio. The new stats are 1 in 54. Are being diagnosed. I'm sorry, 1 in 88 are being diagnosed. 1 in 54 in boys, 1 in 252 in girls. So as that prevalence goes up, the need arises for parents to say, wait a minute, what are my kids' rights? And what are my rights as a parent?
And specifically, in terms of what public schools should offer, are there laws in Alabama that govern what services special needs children do receive in a public school?
There are, and those vary, but they start at the federal level and they come down. There was a federal act that was passed some time ago called the Individuals with Disabilities Education Act. It's called IDEA. So it's got this great, easy name to remember. But basically, it protects all kids, all children with special needs from birth until high school graduation, requires that all children who live in a public school zone, which almost everyone does, receive a free, appropriate public education. That's called FAPE. There's all these great acronyms for it. And that schools place children in what's called a least restrictive environment. And basically that is, they make as many accommodations as possible to allow that child to learn and reach their potential the best they can. And Alabama has a subdivision of the Department of Education here in Alabama called Special Education Services, and they provide assistance to educators, schools, and agencies that serve Alabama children with disabilities. There's other federal laws, No Child Left Behind, most people are familiar with that, sets the standards for how our teachers are certified and what types of teachers we have in the classroom. And then there's the Rehabilitation Act, Section 504, and it basically protects students from being discriminated against at school if they're a special needs child.
Okay. What about IEPs, Individualized Education Plans for Children? First of all, what are they and why do only certain students have them?
IEPs are interesting. They fall under IDEA as well, and basically the requirement for an IEP is a student that has a formal diagnosis of, take your pick, autism, pervasive developmental delay, Asperger's syndrome, whatever the issue is. There's a myriad of different diagnoses. Or they meet certain testing criteria through the school. They get what's called an individualized education plan. And what that does is it requires the school to sit down, go through a meeting process with the parents and the child, and to evaluate what are the restrictions that this child learns under, meaning what are the restrictions they're operating under. I'm doing a poor job of explaining this. Let me try again. It is, what's the best way this kid learns? How can we make accommodations to allow that child to reach their potential? For example, a good way is, say a child has a receptive learning disorder, meaning it's hard for them to understand and language that's spoken to them. They might make accommodations for the way that child takes a test. Maybe it's in a group setting, maybe they're taken from the room and it's read to them, maybe it's they're done in a small group setting, maybe it's done through some sort of pictorial instruction method. And it's not that the content changes or that the child is expected to know less. It is accommodations that are made to allow that child to reach the same educational potential that his peers, his non-disabled peers would have. Does that make sense?
Yeah. So are public schools legally required to provide the special services needed to meet the educational needs of children with learning disabilities?
Yes. The short answer is yes. There's kind of two ways you get there. And one is for the public education system, there are a series of tests and evaluations you can go through. If the child scores below a certain percentage in 2 out of the 3 areas, they would qualify for services. For a lot of kids, they fall through the cracks in this area, though. Say your child scores right on the borderline in one area and just barely above the borderline of average in the other 2 areas. They would not qualify for services under the public education evaluation system, and I think that's kind of a term where they fall through the cracks. But if they had a formal diagnosis, for example, my son, we went through a developmental testing issue with him with a pediatric psychologist. He was eventually diagnosed with autism, and because he has a formal diagnosis from a physician, the state is mandated and the schools are mandated to provide services to him. And as long as they're meeting the requirements that they have to meet, there's federal aid and funding that offsets that for the school. So it's not just local tax dollars, it's federal funding as well to help us ensure the future of our kids because it's such a prevalent and widespread issue.
How about the feedback? Is the progress, are there requirements? I mean, I'm certain there are expectations on the parents' parts, but are there any sort of requirements as far as the school letting that parent know what services are being rendered, progress, I mean, in terms of communication?
Right. Yes, there are, and that's the point one where I think parents don't realize what they're entitled to.
Right.
I know my wife and I didn't really understand what all we were entitled to, and she's a public educator. She works in the Vestavia school system, and so there are 4 specific instances the school has to notify the parents in writing of issues that come up. If the school chooses to evaluate or reevaluate the child, they've got to provide written notice to the parents, or if the parents request a particular type of test to be done to evaluate the progress of the child and the school refuses, they've got to do that in writing, not just in writing but in the parent's native language. So that's a big issue for minority groups a lot of times too. A second issue is if the school wants to reclassify the child or classify a child who has been in the mainstream and they believe that child may qualify for special services. They want to go through the evaluation process. They've got to notify the parents in writing to do that. They've also got to notify them in writing to develop or revise an IEP. That's the most common practice where the school wants to bring in the parents, discuss the issues surrounding the IEP. Has the student met his educational goals? What types of intervention is he going to qualify for? What do the teachers and the special education coordinators recommend as the best way to teach this student in these areas? And to revise that, there's actually a meeting requirement that has to take place between those regular teacher, the special education teacher, the parents, and sometimes administrators. And then any change in the child's placement requires writing.
All right, time for our first break of the night. As we head to break, I want to remind you how you can get in touch with us. You can call, text, email. Also find the firm of Hollis, Wright & Couch on Facebook. Hollis_Wright is how you find them on Twitter. A couple more segments remaining, so get your questions into us. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thank you for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple. Provide answers and legal counsel when you need it the most. Now, your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys here on Alabama's 13.
Important information to know. Welcome back into the Attorneys. Hey, as we come back in for the second segment of 3, plenty of time for you to get your questions to us. You can call, text, and email. We are here with Mallory Schneider and Josh Firth of the firm Hollis, Wright & Couch talking about special education law in the state.
Yes, and in the first segment, Josh told us a lot about the services that public schools are supposed to provide to special needs children. What happens if they don't provide those services that they're supposed to?
That's a good question, and that can be a sticky point for parents sometimes. A lot of parents, we get calls sometimes, and I get friends of ours who ask us, a lot of parents want to run off and file a lawsuit because when you're dealing with a child, it's very personal.
Yeah, it is.
And you're not just frustrated because you're the parent, you're frustrated for your child because you feel like they're being limited in some way. The best piece of advice that my wife and I have taken to heart and we've given friends and I would give anybody is gently remind the school of their legal responsibility. And when I say gently, start at the bottom and work your way up. Start with the child's regular teacher. Have a discussion with them. If that doesn't seem to go anywhere, talk to the special education coordinators and the teachers that are in that department. You have the right to request a meeting with any teacher that has an impact or teaches your child or has a part of their education process. Request an IEP meeting. Request a meeting with the teachers and the principal. Go to the principal themselves and discuss the fact that you don't think the IEP is being followed, you don't think the educational protocols are being met or the goals, or the way that they're handling the goal, you don't feel like there's being forward progress is being made. If that doesn't get you anywhere, go to the school board or the superintendent, and if you exhaust those issues, then I would say it's time to contact an attorney if you haven't seen any resolution at that point. Rarely is it going to go that far. Right. Most schools, particularly we're lucky here, are very good about this and handling it, and they are going to listen to a parent's concern, particularly if it's a valid concern.
Right. What often is the real root of the conflict in your experience and your discussions with other families? What's the root of the conflict most often? Is it misunderstanding? Is it lack of information or even education, even educating the educators on these sort of things? You
really hit it on the nail right there. We're going to talk about that again in a minute, I think, when we get to another topic about inclusion versus exclusion. But, you know, it is hard to be educated well on this topic, not just as a parent, but as an educator. The general, I'm going to use the term the general classroom teacher, your regular ed classroom teacher, because there's so many special needs students within that mainstream body now, those educators need to be educated about special needs students, but that's not what their specialty is in. You got the special education teachers and the resource teachers now coming into the classroom and trying to help. It's almost like a co-teacher role. There's some friction that happens there. Most of the time, it's a misunderstanding. The school thinks the parent may be making some unreasonable demand. The parent doesn't fully understand what's being done with the child. So it requires a very forthright meeting between all the parties to say, this is where John is at. This is what we have seen at the school. And oftentimes, really what it boils down to is the parents need to give more information to the school, and a lot of times the schools are just so busy, but they need to give more feedback to the parent. Right. And that's a large component of it is when everybody gets on the same page, you see the parties work it out 9 times out of 10. Right.
Well, you just mentioned the terms exclusion and inclusion. What were you talking about?
When we were younger, growing up, most of us can probably remember that most special education children were in a separate aspect of the school. They were removed or excluded. Right. Since the 90s, particularly in the 90s and about 1997 in particular, inclusion, meaning mainstreamed for lack of a better term, bringing special needs children into the mainstream classroom and keeping them there for the most of their learning has become the preferred method under the Individuals with Disabilities Education Act. There's multiple reasons for that, and there's multiple pros and cons for it. You'll find a lot of people who are against it, They think that it slows down the pace of learning maybe for a peer student, a neurotypical child. And there are advocates, I'm an advocate for it personally, because it has much greater, I think, impact than just academic. It has a huge socialization component to it where, because the kids who have disabilities are included in the mainstream classroom for most of their educational services, the special needs teachers come in and help and give them those services in the classroom. In fact, 80% of students in Alabama who are special needs get their services in the mainstream classroom, which is, I think, great. But it teaches and allows the peer student how to interact with someone with a disability. It lets the disabled child not feel excluded, but it allows them to interact with their peers on a day-to-day basis. And there is a huge component of socialization that happens there, which really transitions out into the real world later for kids, because they haven't been excluded and only taught on a day-to-day basis with autistic kids with autistic kids, or Asperger's kids with Asperger's kids. They're in the classroom day-to-day with other kids. For example, my child went to an early intervention program in Homewood when he was young, from age 3 and 4 until he started kindergarten. 50% of his class were special needs children, 50% were peer at a young age. The great thing about it is he's still friends with all those kids on both sides. They've all transitioned into school together, and to them, he's no different.
Yeah.
And that is a huge, fighting the socialization battle is really bigger than fighting the academic battle most of the time.
Yeah. At what age can a child, or are there specifics in terms of age, in terms of when a child can begin receiving state services, and also is there an end age for such as well?
Yes. IDEA, again, the Individuals with Disabilities Education Act, requires that public schools in Alabama provide services for eligible children starting at age 3, if they qualify, through age 21.
Okay.
In addition, IDEA, and again I'm using that acronym, it gives states the option to provide early intervention services for children with disabilities from birth through age 2. For example, if you believe your child may be autistic, and I use that example regularly just because it's personal to me and I know the most about it, there is a state services coordinator who can come in and do an evaluation of your child and set up speech therapy, for example, early on, 18 months to 2 years, if your child qualifies.
All right, time for our second break of the evening. As we head to break again, want to remind you of ways you can get in touch with us. Easy for you to do so. We welcome that, in fact, and want to remind you to be sure to check out the firm Hollis, Wright & Couch on Facebook and Twitter. Stay tuned. The final segment of The Attorney is coming right up.
I'm Greg Foster with the law firm of Hollis, Wright & Couch. Whether you're buying a car or have a loved one entering a nursing home, there are many types of contracts that include arbitration agreements. In this week's Legal 411, we're answering the question, what is an arbitration agreement? Arbitration is a way of resolving a dispute. Instead of going to court, you go to arbitration. In legal terms, it's known as a forum selection clause. That means you select where the dispute will be heard. Traditionally, most people prefer the courtroom as their place for the dispute to be heard. That's because a judge oversees the dispute, and this judge is elected by the popular vote. Plus, a jury of 12 members of your community decides the facts of the case. They hear the testimony and see the evidence before rendering a judgment. On the other hand, arbitration has 1 to 3 arbitrators who will decide the fate of your case. These arbitrators are not elected, but are instead hand-picked. If the parties cannot mutually agree on an arbitrator, the arbitrator may be selected from a pool of people who may have worked in the same industry as the individual or company who injured or caused harm to you. And there is no jury. So before you sign an arbitration agreement, here are 5 steps you need to take. First, read all documents thoroughly. If you don't agree, don't sign anything. If you don't understand, consult an attorney. If the business tells you that you must sign an arbitration agreement to purchase a product or receive a service, don't do business with them. Or indicate on the document that you signed it, quote, under duress, or write, quote, I was forced to sign. Particularly in a nursing home setting, indicate on the document that you were told, quote, to sign the document so that your loved one will receive treatment and care. Listen, if you sign an arbitration agreement, you give up your 7th Amendment right to trial by jury under the U.S. Constitution, as well as your right to a jury in the state of Alabama. In other words, when you sign an arbitration agreement, you waive your rights as an American citizen. So it's up to you. Do you want your case to be heard by 12 members of your community or some former employees of the same industry that may have caused harm to you or a loved one? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on Alabama's 13.
Welcome back into The Attorneys. Hope you are enjoying this conversation, covering a whole lot of ground on special education law in the state. This is the final segment, but we have quite a few minutes remaining, so if you want to chime in, call, text, email, get those questions into us for Mallory, Schneider, and Josh Firth of the firm Hollis, Wright & Couch.
Yes, David, and we just got done talking about integrating special needs children with their non-disabled peers. Right. And so obviously you'd think some problems could arise with the interaction of those two different groups of kids. So what happens when you have to discipline a special needs child?
Again, I think I've used this phrase before, but that seems on the paper to present a sticky situation. How do you handle disciplinary actions with a special needs student? For students who are already identified as IDEA eligible and the issues at hand are manifestations of their disability, for example, they can be placed in an alternative setting, alternative school. Most schools have that now, for up to 45 days, the same extent they would be for non-disabled peers as well, but only under certain circumstances. If they brought a dangerous weapon to school, if they were selling illegal drugs on the premises. Again, those are issues you might run into anyways with a non-disabled peer, but also the school has to go through what's called a due process hearing, and at that the officer has to show, or the school has to show to the due process hearing officer that the student's behavior is, and the legal buzz phrase is, substantially likely to result in injury to the child or others. It's a pretty high standard you got to meet. But in order for the placement to be proper, that due process officer has also got to see, and the school has to show, that they made reasonable efforts prior to instituting any due process hearing issues. They made reasonable efforts to address that behavior problem prior to the current incident. Those things can be through IEPs, meetings with the parents, letters home, things of that nature, but there's got to be some effort done beforehand before they just categorically say, we're shipping you off to alternative school.
Yeah. Well, what if at the end of the day, agreement is not reached? What if, say the parent is not happy with what the school decides is in the best interest of their child, or the opposite? What if the school thinks that parent is just expecting and asking too much of us? What is the course of action then?
Usually what that'll result in is a parent, even if the school disagrees with the parent, that disagreement creates a situation where the parent can request what's called a due process hearing.
Okay.
That is done before an impartial hearing officer. It's a lot less formal than a court hearing, but there are some really specific rules that apply. I'll try to go through them very briefly because most of the time you're going to want to get an attorney involved. The school is going to have an attorney present.
Okay.
You should have an attorney present.
All right.
It is a quagmire, for lack of a better word. It's just, it can be convoluted and complicated if you don't know your rights. But parents can offer a copy of an evaluation report done by an outside evaluator. You can have your child evaluated outside the school. Better to bring the evaluator live. Right. For example, if you got a developmental psychologist seeing your child, try to get them to come testify live at the hearing. Okay. 5 days prior to the hearing, you got to give copies of all your written evidence and a list of any witnesses you plan to call. School's got to give you the same stuff. Okay. The school has the burden of proof, meaning it's their responsibility to prove that the proposed program or evaluation or placement is appropriate. So if you, the parent, disagree, you don't have to prove it's wrong. The school has to prove that it's right. But on the other side of that, the parent's proposal can't just be better. It's not enough for them to come in and say, school's wrong, my way is better. That's not enough. they've got to show that given, the parent's going to have to be able to show that given the child's relative strengths, weaknesses, disabilities, ways they learn, it is not likely that they will make meaningful progress given the program the school wants to implement. The hearing's recorded, all the witnesses testify under oath, and within 45 days after the hearing, the officer has to give his written findings to the school and to you. At that point, you can appeal. You could file a lawsuit if you wanted to do so in federal court. But you really, really need an attorney, not just for the due process hearing, but if it doesn't go your way and you are firmly convinced that you're correct, and most parents wouldn't institute due process if they didn't firmly believe they're right, you are going to want to get an attorney involved, particularly at that point, because the appeal process from that can be very complicated and it's a federal law question.
What kind of an attorney would you recommend?
Well, that's a good question. I mean, there are several people who do specialize in education rights, and I'd recommend one of those. Our firm does a little bit of that. What we would really do, what I would recommend is you contact us and we'll get you in touch with somebody who does that on a day-to-day basis. There are a couple of firms who represent the school boards, but there are 2 attorneys who specifically here in town specialize in special education rights, student advocacy, parent advocacy, and we can help get you in touch with those attorneys.
Can you sue in regular court?
You can. You could bypass that process and go straight to federal district court or even in state court. If you want to go that route, you'll have to you should go through the due process hearing first. Okay. The due process hearing is most of the time the best way to get what you need for your student, for your child. In addition, there are some potential defenses that can be raised that you didn't exhaust your previous remedies before you went and filed your lawsuit. That's why it's so important. You got to contact an attorney because there are some little hiccups you could miss.
Right, and just real quickly, what happens to the child during the court proceedings or the due process?
Right, this is what's called the stay put protection. During that process, nothing changes for the child as far as the day-to-day basis. Okay. Where they were prior to the proceedings being implemented, they stay there. And they call it stay put protection. That way, nothing changes for your child, no unilateral decisions or changes are made without your consent. Your wishes aren't necessarily implemented, but it's status quo for the child. They don't have to have an up and down cycle in their educational process.
All right. Just time enough for final comments from you guys. For you as an attorney, but also a parent going through it. Final thoughts from you for
Well, you know, this is one of those situations that is tough to talk about, tough to deal with, tough to be very specific about because every family situation is different. Be an advocate for your child. There's nothing wrong with that. If you feel like your child's educational needs aren't being met the best way possible, don't be afraid to speak up and don't be afraid to call an attorney. Call us. We'll give you free legal advice. We'll be happy to do that, or we'll put you in touch with somebody who can. But the best person your child has to speak for them is you.
Yeah. Mallory, how about you?
Well, Josh's final thought, I just hit it right on point. Parents are often a lot like attorneys because we advocate for our clients just as a parent would advocate for their child. And we encourage that. We want the parents to advocate for their child and to know their rights and to stand up for their rights. And if they need somebody to do that for them, get in touch with an attorney. Yeah,
good advice. Appreciate the insight and good stuff tonight. I hope you found this as helpful as we did. Thanks so much for being with us. Again, if you have more questions, still reach the firm of Hollis, Wright & Couch. Call, text, email, find them on Facebook and Twitter. We'll look for you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.